Right, welcome and very good evening or good afternoon, depending on where you are. Just a quick couple of household rules from our side. I'd be grateful if you could just bear in mind that we'll record the webinar. We will distribute the webinar to all the registrants afterwards. So if you want to share it with somebody or whatever the case might be, you're of course welcome to do so. We'll also post a link to this specific webinar on our social media pages. When it becomes available on our website, all our previous webinars can also be found there. For any questions, folks, please don't use the chat function. Use the Q&A section. You'll see it at the bottom of your screen. It just helps us to manage the inquiries we get a little bit better. You can also upvote a question if there is a particular question that you want answered, so we can be sure to get to it. Any questions we can't get to, just email us and we will be happy to revert you after over the next day or so. The email address is just our normal info@bic-immigration.com. So with no further ado, I'll be grateful, David, if you can join us. Everybody, this is Dr. David Smith, who will be speaking with us first. Thereafter, my colleague Dirk, myself, and Shakir will also be online. Thank you, David. Over to you.
Great. Thanks so much, JP. Good evening, everybody. My name is David, and I'm just outside of London in the UK. And I've run a company for the last 5 years, David Smith Education. And it's based on my experience in the UK education system over 30 years in a variety of roles, teaching first and foremost, but then in a variety of leadership roles in pastoral, academic, and then as a senior leader as a deputy headmaster in a very large UK independent school, an all-boy boarding school. What myself and my team do, we work with families who are relocating to the UK, hence why I've done quite a bit of work with JP Breytenbachs over the last few years, supporting clients who are coming to the UK with their families. And we work with families to support them, firstly, when you are still in South Africa, but then also when you have relocated into the UK. And what we aim to do is to provide you with professional and impartial advice on the many different academic pathways that are available in the UK, depending on the age of your child. So we work with families who are coming into what we call primary school education. So that's for children up to the age of 11. And then secondary education from the age of 11 to 18. And we've also done some work with some graduate students who are relocating into the UK, either from a South African university or who are applying for postgraduate courses. So we work with families with children or young adults at different stages of their academic path. As I say, my background is both across academic and pastoral. I have 4 children of my own, who I'm very glad to say have kind of been there and done that. The youngest of them is now at university, and the others are all kind of grown up and, dare I say, hopefully financially independent and all living up in London. So I hope the advice that I and my team can give you is both from a professional point of view, but also from a personal point of view as being parents ourselves. Applying for schools in the UK comes in different forms and shapes. And if I just give a quick overview of the different kind of profiles that we can support. In the UK, we have a whole host of terminology, which I would imagine some of you might be familiar with. But let me just explain the different types of schools that you might be considering. The first one are what we call maintained schools or state schools, so publicly funded schools. So schools which are supported through taxation. So for yourself coming in, there are no fees. So I will talk about state schools. We then obviously have independent schools. Independent schools are not funded by the state, they're funded by the families who send their children there. So that takes us into the realm of fees and a whole different admission process for those types of schools. We then have what we call grammar schools. Now, grammar schools fall into 2 different camps. You have grammar schools in counties such as where I live in Kent. So these are state schools, so maintained funded schools, but they are academically selective schools. And for that, your child would have to do an assessment. For families who are here in the UK, the phrase we would normally use would be the 11 plus. And that's for admission for a child from primary into secondary. So that's for children who are 10 during the time of the assessment. And then the entry is normally in year 7. So grammar schools are state-funded schools. But what you will also find in the UK is some grammar schools which are selective academically, but they are fee-paying schools. So welcome to all the different terminologies. I'm sure you have similar situations in South Africa. So for someone from outside, it perhaps appears a little bit confusing, but that's the work that we do to support you to understand all of the different options, the different pathways. Now, again, if I just talk about some of the key staging points in UK education, just so that you can perhaps plan when might be best for you and your children to relocate to the UK. As I say, primary education will start when a child is what we call a rising 5, so that's when they are age 4, and that year group is called Year R, so reception. They then progress each year. Obviously, September is our start point for our academic year, and that's an important reference point to keep in mind when you come up to the UK. We work with families who are relocating at all different times of the year, but inevitably that can create some challenges, can I call it that, if you're relocating during the course of the UK academic year. If it is at all possible, a relocation into the UK during our summer, so July and August, ready for the academic year that starts in September, there are a number of advantages if you can time it in that respect. But as I say, we work with families who are relocating at many different times during the academic year. Primary education will go up to the end of year 6. So that's when your child is 10 at the start of the academic year and has their 11th birthday. So secondary education will start in year 7 for a child who is aged 11 on September the 1st. And then it progresses up year by year. So the key next point is what we call the GCSE years. So those are year 10 and year 11. So that's when your son or daughter would be 14, 15 and having their 16th birthday. GCSE is the General Certificate of Secondary Education, and those assessments are done at the end of our academic year in year 11. So that would be in the May, June, early July. Students then progress beyond GCSE to what we would normally expect as advanced level or A level. And that's a 2-year assessment process where students select normally 3, sometimes 4 subjects, and they study those courses for 2 years until they complete their assessments at the end of year 13. So that would be the academic year when your son or daughter is 17 at the beginning of it and then turns 18. And then we're on to higher education and university, if that's the route that your son or daughter wishes to go. And the process for applying to UK universities starts at the beginning of that final academic year. So in the September, October, November of year 13. A couple of just very practical points. I would imagine that you probably will have a whole variety of different questions depending on your own particular needs. But I just want to share a couple of, I think, very practical considerations to bear in mind. And I want to talk, first of all, about applying for UK maintained schools, so non-fee paying. If you're intending to apply for a UK maintained school, you will need an address in the UK. Education is managed by what we call local education authorities, or LEAs. And for all LEA applications, you will need an address. And this is a challenge, and I fully understand this. And whenever I'm talking with a local education authority explaining that I'm trying to support an overseas family, we do have the egg and we do have the chicken dilemma. Because I would suspect that some of you are thinking, well, if we know where the good school is, we'll get our child into the school and then we'll worry about accommodation second to that. Unfortunately, the process is completely the other way around. And so I always advise families that we can offer guidance and support in terms of identifying the schools that could be appropriate for the needs of your child. But we can't start that process until we know where you're going to be in terms of an address. And in terms of actually starting an application process, we need proof of evidence of either a tenancy or the purchase of a property. The other key point to bear in mind is the time frame for applications for maintained schools. Because if a local education authority makes an offer to you for your son or daughter to start in a particular school, the offer will be made, and then your son or daughter will need to be in the school within 10 days. These are school days, possibly 15 with some negotiation, possibly 20. So again, that window and the time frame for applications is quite a tight one. And so if, for example, you were to advise me that you were going to relocate to the UK in, say, January 2025, we can offer some guidance and ideas on pathways and where perhaps you might like to consider given your work needs. But in terms of the application process, that would happen after you've worked out your accommodation and about 3-4 weeks before your arrival here in the UK. So there are some very practical considerations with respect to maintained school applications. We also work with families who are considering non-maintained schools. So these are the independent schools or the fee-paying schools. And we work with families who are looking at entry at all different levels. So possibly into what we would call a prep school. That's a school traditionally for children aged between 7 and 13. And then a senior school. Some senior schools will start at 11, but perhaps the traditional English boarding schools, but also with day provision, they will often start at age 13, year 9. And again, we work with lots of families looking at different schools. We can offer guidance and support and explain the timeline and that process. And it is quite different to the maintained sector. And depending on the school that you perhaps are thinking of, that time frame for applications can start anything up to 3 years before. So it's a very different process and a very different timeline. But as I say, we work with families who are looking at both maintained and the independent sector. We can also support families who are considering higher education as a route and guide you through the UCAS application process. And again, just one practicality, if I share this with you, and this is the support that we can offer to you, is guidance on your son or daughter's status in terms of making applications to UK universities and the distinction between what we call a home status student and an international student. And that comes down to the fees that you will be liable for. So again, in terms of just supporting and helping you, whatever age your son or daughter is, we can offer guidance at each step, at each stage of the process. I'm just going to share my screen just to emphasize some of those points that I've mentioned. So let me just bring this onto the screen for you. Here we are. So I hope that you can, it's okay on screen, applying to UK schools. So just to repeat my own personal background, I went to a UK boarding school. I ended up doing 4 different degrees, not by design, but it just kind of happened like that. And I ended up doing a doctoral research degree. And I taught for 30 years in UK schools and also had leadership responsibility. And as I say, ended up as a deputy headmaster before I set up my company. The key mission for all the work that we do with our team is to support families make informed choices and to ensure that you are aware of the different pathways, the different routes, selective, non-selective, state, independent, and to make sure that you are fully aware of the timeline for your process. So if I identify 3 steps and stages, the challenge, I've relocated within the UK 3 times, and I've done that with 4 children. So I'm aware of the challenges of moving house and trying to organize work, family and schools around the challenge of relocation. But I've never moved from another country. So I take my hats off to you if you are contemplating this. And what we can offer is obviously we are here in the UK. And so we can give you that inside track, that understanding of the different school options, the different school structures, the process for admission, which, as I say, for some independent schools can be quite a long one. The solution, therefore, to some of those challenges is to work with us so that we can share our detailed understanding of the UK education sector in all of its forms. At the heart of the work we do is a consultation with you and getting data so that we fully understand the needs of your child. And that includes also where there might be some particular special educational need provision to allow your child to access the full curriculum. And we can support at each step and stage from selection through the admission process. And if it's an application that involves assessment, we work with a team of tutors who can ensure that your child is ready and prepared. So we like to think that the benefit of what we offer is something that can be very tailored to your particular circumstances. So where you need to be from a work point of view, perhaps where you need to be from family and connections within the UK, but most importantly, it's ensuring that everything we do has your child's needs at its absolute core and centre. This is a grid just to quickly summarize the points I was making about the different entry stages. So we've got state schools on here, private schools. So as I say, you'll notice that the academic years in the UK run through from when a child is in year R, reception. That's for 4 going on 5, sometimes called rising fives. And then it progresses through. Year 1 is for children who are 5 on September 1st, and so on. So I think probably the key date in here, just to reinforce this point, is that if your child is under 11, you are looking at primary education. If they are 11 and older, it is secondary. And the key age of that transition is year 7. So that's when your son or daughter is 11. The other key point to note from here is year 10 and year 11. That's the 2-year GCSE course. So we do support families who are moving when their child is in the middle of what we would call the GCSE process. I think if it can be avoided, I would strongly encourage you to do that. But we can support and help you at whatever point and at whatever stage you are needing to make your relocation. So to finish, my own background, as I say, 30 years of experience of working in an academic and in pastoral roles. I have strong links with a large number of schools, and I work with a lot of different support groups. So if we have a particular need that we can't deal with, we can certainly link you up so that you are getting the very best advice for your particular family's requirements. As I say, we work from both a professional point of view, but also inevitably as a parent of 4 children. I don't share my children's own profiles or backgrounds, but they are all very different, as I'm sure your children are. And so they are a reference point in terms of how I can share and understand the questions and perhaps some of the concerns that you might have making this move to the UK. And I think, as JP said in the introduction, I'm very happy to take some questions in the Q&A, but I can give my email contact through. So if you do have any queries and you would like to have a further discussion and meeting about your particular needs, I'd be very happy to respond to that. So please do send any queries that you have through to Breytenbachs, and then they can forward them on to me at David Smith Education. Thank you so much for your time. I hope that's been helpful and useful. And I hope that maybe in the next few weeks, I'll have a chance to talk to some of you and get to understand your plans and hopes for coming to the UK. Thanks so much.
Thank you, David. Excellent as always. I will also impose upon you. I'll ask very nicely if you can maybe do a short sort of summary or note for us at some stage that we can send out to our client database. I think what you're doing is incredibly important.
Absolutely.
And I know for the vast majority of my clients with children, one of the main reasons they move to the UK is for their children and the children's futures. And it is incredibly complex to navigate, well, just moving abroad, never mind finding the right schools and setting up your child really for their future in the UK. So thank you very much. I see there are a couple of Q&As for you already, and I've rather selfishly jotted down 2 questions that I'm going to ask first. But I think just before we get to that, I think if from the Breytenbach side, we run through a few things and then we can address again at the Q&A thereafter. So thank you, David. Dirk, if you can be so kind as to join us.
Yeah, thank you very much, JP, and thank you, David, for that as always. It's always a pleasure to have you on. Just going to quickly share my screen with you all, then we will be on our way. Let's do that. All right, so I'm hoping my screen is up with all of you tonight. So yeah, good evening from my side, ladies and gentlemen. As you can see, my name is Dirk, and I'll be able to take you through some of the changes that have been made to family migration in the UK, in specific reference to the minimum income requirement and so forth. So just once again, JP introduced the speakers at the start of the webinar, so we'll run through them as we go along. Right, so the very first thing, ladies and gentlemen, to understand is since right around 2012, the Home Office has introduced something they call the minimum income requirement. Now, this is a kind of eligibility requirement that has to be met by partners, children, and parents on applications for family members. Now, very briefly, what this means is that we are joining or accompanying a British citizen to the UK for relocation. Now, up to 11 April 2024, the minimum income requirement was set at about £18,600, and you also had to prove additional income points for each child added to your application. Now, as I'm sure a lot of you know, the big announcement was that the minimum income requirement would be increased. And as of 11 April 2024, we saw the increase go to £29,000. One good aspect with that, there's no longer an additional amount that needs to be proved for each child accompanying you in the application. It's also very important to remember that there's various factors that will have an influence on how this requirement could be met, such as where you are based, what your current immigration status is, your personal circumstances, etc. The Home Office announced on the 4th of December, in a bid to reduce the net migration, that they will be upping this minimum income requirement. As I've stated, we are now on £29,000, but there are mentions, or that it was announced rather, that they intend to go up to 34,500 in Q4 of 2024 and 38,700 at the start of 2025. Now, it is very important to note that these are announcements, but that's exactly what it is at this stage. We await further guidance from the Home Office to see if and when this will be implemented. But be sure to have a look at our socials and our newsletters and website for that matter to receive updates on that. Another very important and beneficial point for us is that applicants rather that are already in the UK and importantly already on the family route may use the transitional arrangements that are in place, and this will allow you to meet the minimum income requirement by still meeting the previous number. To give you an example, someone enters the UK as a fiance, gets married, and then extends their leave as a spouse, you will need to meet the previous minimum income requirement of £18,600, provided that your first application was before 11 April 2024. Going on, briefly touching on the methods that we can use to meet the minimum income requirement. So there's mainly 5 methods that we can use. And we're going to run through these very quickly. I'm not going to go into depth because we'll be sitting here all night, quite frankly, if we need to discuss these in depth. So the very first one is income from salaried or non-salaried employment. This is only applicable to the partner, and where I refer to partner, this is the British citizen in this scenario. And in some instances, the applicants can also be taken into account, but they need to be in the UK on valid leave when we use that. We can also use non-employment income, which includes income from property rental, dividends, and so forth. Then third aspect, which is a very popular one to use, is the cash savings aspect. Here we can use the cash savings from both the sponsor or the partner and the applicant, and we can use any savings above the amount of £16,000. Very importantly is that these funds need to have been held legally by the applicant and or the partner for at least 6 months, and it has to be under their control. There are some exceptions to the 6-month rule. Won't get into depth with that now, but it relates to the sale of property, sale of shares, that sort of thing. We can also use state pension, UK and foreign, occupational or private pension. And then the very last one is we can use income from self-employment and income as a director or employee of a specified limited company in the UK. Now, that's a very tricky one to prove. So if you have any questions and that's your scenario, reach out to us and we can discuss it further. One aspect that I briefly also want to mention is the UK, in the UK's rules, they have a provision that allows the family essentially to meet the financial requirement by way of the adequate maintenance test. This is only applicable if the British citizen in this scenario is in receipt of certain benefits in the UK. Now, the adequate maintenance test is also quite a tricky test to prove, but essentially what it boils down to is that we need to prove that the income that the family receives, less their housing or what they pay for housing in the UK, must be more than what a family of that size would have received in the UK if they were in receipt of income support in the UK. Now, one other thing I briefly want to mention is if the British citizen, the partner, is a member of Her Majesty's Armed Forces or Her Majesty's Armed Forces service leader, then the income requirement comes down to £23,496. Doubt that it will apply a lot, but you never know. Then from my side, very briefly, just to explain the Home Office fees to you guys, we have 2 fees that needs to be paid essentially, which is an application fee and immigration health surcharge. Application fees for people applying from outside of the UK is £1,846 per applicant. And if we apply in the UK, it's £1,048 per applicant. In the UK, would only apply if you're extending, varying your leave, and that's basically the only ways you'd ever see that. Then, very important, the immigration health surcharge has gone up on the 6th of February 2024. It is now £1,035 per adult per year, or £776 per minor per year. Important to note as well, these fees are calculated and payable upfront according to the length of the visa you receive, or the length of the leave you receive, rather. To give you an example, if you apply as a spouse to the UK, you'll need to pay this for 3 years upfront, which would equate to £3,105. Just giving this as an overview to you guys, just to show you how important it is to do these applications correct the first time, because it is quite an amount that you need to pay for this. I'm now going to hand over to JP to take us through some other routes. Thank you for listening, and we'll see you later on in the Q&A.
Yeah, thanks, Dirk. If you can move on to the next slide, please. Or not, we can just look at my pretty face. Okay, thank you. Just to add something else, Dirk, 2 things quickly. And Shakir, forgive me if this is something you're going to deal with, but there's been a change, but a good news, I guess, in terms of the unmarried partner requirements. Someone always had to have lived with your partner, if it's an unmarried partner, for 24 months preceding the date of us being able to apply. That has now changed. So you have to have been in a relationship for 24 months, not necessarily had to have lived together for 24 months, which is quite a substantial change, which could benefit some. I'm oversimplifying, but that is sort of the crux of the matter. So any questions on that, let us know. I'll just very briefly want to touch on 3 different types of applications that all 3 of them are pretty complicated, but I just think it's important for people to know the options are out there. The first one is what's known colloquially really as family life as a parent. The idea behind this visa is if you have a child in the UK that lives there with his or her mother or father, who are British citizens, and you are abroad, but you want to go live in that same country with your child, and you're not in a relationship with that child's parent anymore, then you can apply for this visa that allows you to go live in the UK, work and get on with life, and be with your child. The child doesn't have to live with you, don't have to have full custody of the child, but you do have to be involved in the child's life. And of course, we have to prove that. There are various ways of proving that, but it is something that is often overlooked. And it is something that I think is important for people to note if families are split up and that relationship has stopped being an ongoing one with the child's parent. Another one also to do with children is what's known as indefinite leave to enter. So this is an application under what's known as Part 8 of the immigration rules, 297 specifically. It's a bit of old law before 2012, really. As Dirk mentioned, in 2012, the new laws, July 9th, I think it was, the new laws came into play. So effectively with this type of application would be the scenario generally where both parents are British citizens, but the child, for whatever reason, can't register as a British citizen. For example, both British citizens were born in South Africa, but have never lived in the UK before. That is when we'll do an indefinite leave to enter application. The benefit of this is that the child will get indefinite leave to enter, which effectively is the same as indefinite leave to remain. So that child will immediately be free from immigration restrictions. Generally speaking, after 3 years, we can then register that child as a British citizen under certain circumstances immediately upon arriving in the UK, but it's quite rare. And the minimum income requirement doesn't apply. The test in order that applies there is one of adequate maintenance, which is what Dirk briefly described earlier. The final application to mention here is, again, what we sort of refer to as the adult dependent relative. This is a very, very complicated application, unfairly so, I think. Effectively, this is if you've got a parent or grandparent or some form of family member, generally a parent or a grandparent, that can't live abroad on their own anymore due to age, illness, or infirmity, and if care isn't available in that country. So, for example, scenario, if somebody's mother or father is ill, elderly, and they can't continue to live in South Africa on their own, and there is evidence really that we can provide to prove that, and there's no other care facilities available in South Africa, or it's simply unaffordable, then the application to be made is this one of an adult dependent relative. It's an entry clearance requirement, so you can't be in the UK, let's say, as a visitor and then apply for your parent to stay. There are other applications which one can make if the facts justify them in that scenario. So if a parent's visiting you in the UK and they can't travel back to South Africa or wherever in order to apply for this visa, it gets really complicated, and it's a human rights based application. But if there is anything like that, please do reach out for us. And just sort of as an overarching final sort of thought from my side, please bear in mind everything we're telling you today is the basics. As Dirk mentioned, if we have to delve into depth on all these various categories, we would be here for days. It really has become very complicated. And I would encourage people, just reach out to us. Don't give up before you think, well, it looks so difficult, I'm never going to be able to go to the UK or never be able to join my family in the UK. Rather reach out to us and let's see if we can't make a plan. We'll mark a plan, as they say. So please always feel free to do that. info@BIC, or email me directly, jpb@bic-immigration.com, and we'll do our utmost to assist where we can. So now over to my learned colleague, an absolute gentleman, Mr. Shakir Hussain. Shakir?
Thank you, JP. Good afternoon, good evening to everybody. As JP said, my name is Shakir. I am the senior immigration consultant. I'm also a non-practicing solicitor, which means I have qualified many, many moons ago. You can probably tell from all the white hairs and the gray hairs on my face. I generally specialize in more complex matters due to the number of years. Obviously, I've been working in immigration. So, and a lot of my work focuses both on private life applications and appeal work as well. And today I just wanted to run through, not in great details with yourself, because once again, to reiterate what Dirk and JP have said, unfortunately, if we start to discuss each and every separate category, we would be here for quite some time. So I will just go through generally with the categories whereby people can make applications based upon their private life in the UK. Now, the first thing that you have to bear in mind is when you make these applications, the applicant must already be living in the UK. Okay, so that's the first condition that an applicant must satisfy. Thereafter, there are different categories under which an applicant can apply. So, for example, if somebody is under the age of 18 and they've lived in the United Kingdom continuously for at least 7 years, and it would be unreasonable to expect them to leave the United Kingdom. The best example I can give of that is parents enter with a child. The child has been living there for 7 years, and thereafter, obviously, if you can prove that it would not be reasonable to expect the child to leave the United Kingdom, an application can be made. Now, with all these private life applications, I should have said at the beginning that it doesn't matter how the 7 years, for example, have been accumulated, whether that is a mixture of legal stay inside the United Kingdom or it includes periods of overstaying as well. So even if there are periods of overstaying, that could be the whole 7 years. That's absolutely fine. The rules do allow that, and the rules do not state that the person must have lived there legally inside the United Kingdom. The next basis upon which somebody could make a private life application if they are aged between 18 and 24 and they've lived in the UK continuously for more than half of their life. So again, the date of application, it means the applicant must be aged between 18 and 24. So obviously if they're 25, then unfortunately this rule does not apply to them. And again, it must be at least half of their life, and it does not matter whether that period that they have spent inside the United Kingdom, whether that was accumulated through legal residence or unlawful residence. Next category is the applicant is aged 18 or over, and they've spent at least 20 years in the UK, and they would have very significant problems living in the country that they would have to go back to. Now, obviously, when we talk about very significant problems, that is very much a subjective test in regard to the actual person and what their situation is and what their scenario is. But generally, if somebody has lived inside the United Kingdom for over 20 years, obviously one would assume that they've generally lost contact with any friends or people that they may have had in their country of origin. So, but again, this is very much case-based, and it really does depend upon each individual case as to whether the reasons that there have been, whether those reasons they are putting forward, whether they are very significant or not. So again, in that kind of scenario, as with the previous two as well, I would always advise somebody in that situation to have a consultation, and so that we can make an assessment and we can then set out to that client what their options are and what the merits are of any proposed application is. Next one is they've been in the UK continuously for 20 years. Again, the 20 years one, this one, it is the significant problems are not contained within this rule. But again, if we are arguing a matter on the basis that somebody's lived here continuously for 20 years, the Home Office will expect to see evidence of 20 years residence. Now, of course, people that come to the United Kingdom, they go to different countries, they don't expect themselves to be in that situation 20 years down the line. So it can be sometimes problematic whereby trying to prove their 20 years residence. And the example I can give you of that is I did have a gentleman who had been lived in the United Kingdom for over 20 years, but they literally had very next to nothing in the form of evidence. But through getting references, getting evidence from third parties, collating all of this, we were eventually successful in that application. Finally, if somebody is born in the UK to a person who has permission to stay in the UK on the basis of their private life or is applying at the same time, that child can also apply with the main applicant. So those are the main reasons that they set out. Now, in addition to this, these are the grounds which are set out under the immigration rules. However, of course, an applicant can always make an application on the basis of outside the immigration rules. So an applicant can argue that they don't fit into any of these categories, but as a result of what their situation is, they still wish to make that application. That again like all the other categories, is very much a fact-based approach. We have to look at the client's personal circumstances, what their situation are, and then, of course, make an assessment and make a judgment. Now, whenever we have a consultation with our clients, we are under a duty to advise them of the merits of their proposed application, and that is something that we do provide to our clients, both in the initial application and in writing, if they do decide to proceed further with us. Now, Dirk, if you could move on to the next one. Thank you. The next thing I want to discuss, which touches on slightly what Dirk discussed earlier on, which was the fee, the Home Office fees that are payable for these applications. Now, do bear in mind, once again, these fee waivers which I'm discussing are really for applicants who are already inside the United Kingdom. So the rules do allow a person to apply for a fee waiver if they cannot pay the application fee, okay, because they do not have, or a place to live and they cannot afford one, or B, they have a place to live but cannot afford their essential living costs like food or heating, or C, that they're on a very low income and paying the fee would harm their child's well-being. Now, these are unfortunately a very high threshold level that you have to fulfill. And again, it is entirely case dependent. So in this kind of scenario, when applying for a fee waiver, the Home Office will always want to see evidence of what income the applicants and any or dependents have coming into the family, what their expenses are, what their expenditure are, and they will want to see documentary evidence, for example, bank statements, pay slips, etc., etc. So it is quite a high threshold level to meet this fee waiver requirement, but that does not mean, obviously, they cannot be met. And we have had applicants and clients who have been successful when applying for fee waivers. But I must stress once again, it really comes down to each individual case, what that person's and their family circumstances are, and we then take it from there. With the Home Office, always please remember, whatever you allege, whatever somebody is claiming, alleging, they must have to back it up with documentary evidence. Now, if, for example, somebody's living inside the United Kingdom, they're relying upon, they're not allowed to work themselves, for example, and so therefore they can't apply for a fee waiver. Even in that scenario, the Home Office would want to see evidence of, okay, if this person is not allowed to work, they're not allowed to claim benefits, how have they actually been supporting themselves? So we are required to provide evidence, whether that could be family support, third-party support, friends, or something like that. But if there is such a scenario, such a situation, we are required to provide the evidence together with confirmation from whoever the third party or the family member as well, confirming that they have been supporting that friend or family member, whatever the case may be. Now, with these applications, like I said initially, it does really come down to each and individual circumstances, what their case is, what their scenario is, how long they've lived there. So there are a number of factors that we have to always take into consideration. So it's always very difficult to say to a client, a prospective applicant, that, you know, we believe that you will fall into this category without us getting the full instructions, without us getting detailed information from that client. So I would always recommend that if you are in this situation, or you have friends or family who are in this situation, it is very important that they do have that initial consultation, so that a frank and honest assessment can be made, that can obviously be informed to that person, and then obviously we can take it from there. Thank you for your time this afternoon. Sorry, finally, the exceptional circumstances. Again, exceptional circumstances, it does really come down to each individual case, and you have to prove that the refusal of the application would result in unjustifiably harsh consequences for the applicant, their partner, or a relative child. Again, it really does come down to what their scenario is, what their situation is, as to whether their situation would mean that it would result in unjustifiably harsh consequences. So again, backed up with evidence, generally medical or whatever the situation may be, and put forward to the Home Office. But again, it is very, very much case sensitive, and no two cases are ever the same. So again, it is very important that applicant, their family members, their friends, seek the appropriate legal advice before starting anything at all. Thank you for your time, and obviously any questions and answers you have, we'd be happy to address them.
Thank you, Shakir. Right, if everybody can join me, we can, or the panelists, we can attend to some Q&As. David, when you're ready.
Yeah, absolutely. I've just read through a number of the questions, and so what I've done is I've just jotted down some very quick points that might have relevance for a number of you. Can I just echo very much what Shakir said there about case sensitive and no two inquiries are the same. Certainly that's what I find, and I suppose that's what's enjoyable, because we get pulled and pushed into different routes and courses depending on the needs of the family and the child. Can I just quickly go through a number of points? The issue of a child's status, obviously the child is in the UK because you are in the UK, and therefore they are a dependent, and therefore as they have residency rights through whatever visa you've come into the UK on, they have full entitlement to UK education. This is within the maintained sector. And that's the case irrespective of what your visa status is. If you are here legally, your child is here as a dependent, and therefore they can apply, and we can support you for maintained school applications. Can I mention this term for you? In-year admissions. So if you are arriving in the UK, and let's say for sake of example, your son or daughter is going into year 9, so that's within the secondary sector, that application would be called an in-year admission, because it's not the normal admission point. For secondary education, that would be year 7, when your son or daughter is aged 11. So any application for another entry point, both in primary and in secondary, is called an in-year admission. In terms of the dates for applying, if you're applying within the maintained sector, if you were living in the UK now and you had a child in September this year who is in year 6, so that's the final year of primary, you would apply through the local education authority in September and October. And then you would be advised of the school that your child has been allocated on March the 1st. And that time frame applies across the entire country. Now, if you were to miss that process, so for example, if you decided that you were going to come to the UK, but you made that decision in, say, November, December, after that application window, then your application would be considered, but not until offers have been made for children whose applications went in the September-October timeframe. So this is why so many things are time sensitive. So the moment you start to think about coming to the UK, don't hesitate to get in touch. A year, 2, 3 years, if you're thinking of an independent school, with us, and we can guide you about what are the key timeline points that you need to have on your mind. Home status for university applications. The home status issue is you will get fees, but your fees will be home status fees. So at the moment, that's £9,200. These are not upfront fees. You can apply for the tuition grant, and then you repay that tuition fee once you are in employment and your salary is above a certain threshold. I think the figure is somewhere in the order of about 25,000, 26,000, but I'd have to check that. But you're not paying, as a home status student, 9,200 a year. However, to be eligible for that home status, your son or daughter will have had to have been resident here in the UK for 3 years, and obviously be a UK national or have settled status. So 3 years is a key time frame to consider. So if you are coming to the UK and your child was 16, they're coming in for 2 years to do A-levels, they would not have home status for university applications for the September after they leave school. So they may have to consider taking what we call a gap year between finishing secondary education and starting university. Admission entry points. The number of you have raised questions that your son or daughter might be in a particular type of school, possibly an international school, or maybe your son or daughter is in the year above or perhaps the year below to where they normally are. The first thing I'd want to know about your son or daughter is a date of birth. And we do a very quick translation into what that means within the UK system. And just listening to some of the immigration advice there may be what we might call mitigating circumstances, particular reasons why your son or daughter is up or down, compared to where they should be. And that's where obviously we can have a discussion. But that would need to be evidence supported to explain why we should be looking at an entry point above what their age would say. And as I think Shakir was saying, with all inquiries, we get to know your particular circumstances to understand why we might need an out-of-year admission. That means not the normal age entry point, and that's where we can then enter into a discussion with the relevant independent school or with the local authority. Can I just talk about special needs provision? And we've worked with a number of families who have children who've got particular learning needs, and we can support you in terms of guidance and advice to those schools that might be appropriate for you. But you will, if you have a child with a particular educational need, you might have had an educational assessment done, and you might have the equivalent of what we call in the UK an educational health care plan, an EHCP. And so if a child was here in the UK and the parents and the school believed that there was a particular need that they couldn't support, they would request an assessment of the child to get a statement, a referral statement, and that's known as an educational healthcare plan. And that is the passport that you need to get a referral to a special educational needs school. Now, in very rare circumstances, local authorities might accept the evidence base that you can offer from South Africa. But I'll be honest, in most situations, we do a normal school placement and then we start that application for an assessment once your child is within a mainstream school. So that can raise a number of challenges, but as I say, there are routes forward there, but we can guide you with your particular needs. And then finally, just one question that's come through from a couple of you is about variety of qualifications post-16. So GCSEs, General Certificate of Secondary Education, is the national qualification for children at 16. And what you would normally have is children doing what we call a core content, normally 5, possibly 6 subjects, with all the subjects you'd anticipate. So English, math, science, sometimes possibly a language. But that would be what we would call a core curriculum. What you'd probably find with many children, both within the maintained and certainly within the independent sector, is that they would probably do a profile of 8, 9, 10. Sometimes when I hear students doing 11, 12, 13 GCSEs, I think they're kind of slightly boasting, but good for them if they can do it. So that's the qualification that your son or daughter would do at 16. Beyond that, again, this is where we can support and advise on all of the different pathways. For a lot of students, GCSE is the foundation to move on to advanced level, which is the preparation for applying for university. But for some students, that's not the appropriate route. And so there are a lot of alternative courses. They're known as T qualifications, technical qualifications. These are very often vocationally based. They will often involve internships, so working within industry, but also having tuition within a college of further education. So there are many routes at 16, as there are post 18. And as I say, in terms of university applications, some students go for what we call a foundation year prior to doing their application when they are 19. So we can guide you in terms of what the different routes are and what are the qualifications you need at different levels to make that progression. So again, just a practical one, which I know some of you may be aware of. We talk about GCSE qualifications in what we call Key Stage 4, that's 14 to 16-year-olds. So those are known as Level 3 qualifications. If you then progress to A-levels, you're into Level 4 qualifications. If you then go on to university, Level 5 qualifications. So there are terminologies that we can help and support you with so that you can understand all the jargon on the websites and the literature. And then the final one I'll just mention is about that date for applying if you already have a UK address. And as has come through, obviously, with all the immigration guidance, it's about having the evidence to support it. So if you do have a UK address, then obviously you can proceed with an application, although you may not be here in the UK at that point, but you will need to provide the evidence that you either have ownership or you have a confirmed tenancy agreement in place. Otherwise, a school will not consider your application. So I think I've covered quite a few of the different question points that came in. But as I say, any inquiries that you have, I'd love to have a chat with you. And as I think we've heard this evening, no two cases are the same. And this is certainly the case with your children. Okay, thanks so much, JP.
Thank you, David. If I may, I know you have to run quite soon, but if I may, I'll just have two questions I frequently get asked. I think the one question is, if all things being equal and clients can choose when they want to go to the UK, what is the best age for the child to enter the school system? I went to the UK when I was 15, straight from Alkmaar, very Afrikaans school. And then I went to Davies Lying in Dick, the old Crammer in Notting Hill.
Oh, yes.
Yes. And then I went to Highgate Boys for my A-levels in Highgate.
Fantastic.
Of course, now they're co-ed, so that's different now. But back then it was just boys. So, if you were to, I know it's an incredibly difficult thing to advise because again, it depends on so many variables. But what is the best age for a child to go? Is it just a matter of the earlier the better, really, or is it for them to finish the South African primary school and then go? What do you think?
Well, I suppose it's going to be driven by the needs of the family in very large part. So as I said in my presentation, we understand that families are moving for a whole range of reasons. I think probably the way I would answer this is I would say, if you can avoid, whenever I hear we've got a child who's age 15 and the family are hoping to arrive in the UK very soon, I have to be honest, I wouldn't say my heart sinks, but I kind of go, okay, this is going to be interesting because you're basically arriving in the middle of GCSE. In the same way, if we hear that a child is 17, I would go, okay, this will be interesting because you're arriving in the middle of A-level. But look, life happens and we have to respond to those challenges. So there are always solutions. That's the thing I would always say. But in terms of the best time, I think if you are considering a relocation and you've maybe got 2-3 children, if it's at all possible to plan this so that you arrive, so that your eldest child is coming into the early years of secondary, so year 7, year 8, even possibly year 9. So that's the ages of 11, 12, 13. I think that's a really good time to arrive because it will allow them to adjust to the difference. And there is a bit of a step between where a child might be within the South African system and the UK system, just because of when we start school. We work with a very big tutoring company in South Africa, so we can organize tutoring in advance of your arrival to try to minimize the step up that your child might need to make. But I think arriving age 12, 13, 14 is a great time. They can start the socialization, build that friendship network and the familiarization with the UK school that they're in, so that when they start their GCSEs, the all-important national qualification, they're settled and they're kind of into the loop. That's not to say if you have circumstances that require to move and your child is 14, 15, there is always a pathway that we can create. But I think in short, if you can avoid arriving during GCSEs, if you can arrive avoiding in the middle of A levels, there's a lot to say for following that path.
Absolutely. Thank you, David. And my last question, I think I might know the answer to this, but what is the most common mistake you see people making when they navigate this journey? From our side, it's people not planning properly and not taking the time to plan in advance generally. But from your side, what is the thing you see?
It's timing. And I suppose that there are certain locations in the UK on the London belt which are very popular for all the reasons we understand in terms of commutability into London, services, facilities, and every criteria that we all want to look for when we want to live. And if you decide that's where you want to live, you can guarantee there's a lot of people here in the UK who already live there. And so if you're going to navigate your way through those pressure points of primary, but particularly secondary education, I think you need to think a good year and a half in advance so that you put yourself in the very best position for a pathway for your child. There are certain locations on the London Rim and obviously in other parts of the country as well, where the competition from UK families is very intense. And if you arrive in the middle of our academic year into a particularly competitive area, there are some challenges. And I would be lying if I didn't say that. If you are thinking about the independent sector, and we work with many clients who are going down that path, the timeline again can be anything up to 3 years, depending on the school that you're considering. So absolutely, JP, if you're coming to the UK, wonderful. But the more time you can give to the preparation on the education front, the better it will be, definitely.
Absolutely. Can't agree more. Thank you so much, David.
Okay.
Right,
Thanks
I
so
think
much. Okay.
Yeah, if you've got to run, we completely understand. If you want to stick around, of course, you're welcome. But I know you've got a place to be, so I'll leave that up to you.
I've got a commitment I need to go. But as I say, anyone who would like to get in touch, please do so through JP. And if your inquiry comes through, then we can set up an individual chat and meeting. Okay. Thanks so much.
Absolutely.
Okay.
Thank you, David.
Bye-bye.
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 Rightio, folks. Shakir, Dirk, so I think just not to stretch this webinar out too long, but I think there's a couple of questions maybe for us as well. I would just also like to add again with David, who's been very kind to share his time with us. Any questions for him? info@brc-immigration.com or to me, and I speak with David frequently. We all do. He's an amazing resource for our clients. Happy to pass anything on to him and put you in touch. He's generally somebody worth keeping in mind for schooling. Right, so Shakir, maybe sort of the first one for you. British citizens who are teachers, exempt from income thresholds for spousal visa?
Short and sweet answer is no, nobody's
Yeah, if
exempt.
only.
Unfortunately, when you talk about spouse visas, you've either got to meet the minimum income requirement or the adequate maintenance requirement. So it's always one requirement or the other. So unfortunately, no, they are not exempt.
Yeah, exactly. Unless one of the 10 exemptions apply, right? Read the small print. But I mean, again, we'll be here all evening. So Anonymous said, my husband, UK citizen, I'm in the UK on a spouse visa, our son's dependents, renewing in June of this year. Easier to show cash savings for financial requirement than salary, directors of own companies, so self-employed, or can salary dividend be used? What will be the minimum cash savings? So maybe if I just take this one, if I may, gents. It really does depend. It's impossible to say because, of course, we don't know what the income from the company is. As a general rule, you can rely on directors' drawings in this case and dividends. You can combine those. Very difficult to combine cash savings and self-employment income as a general rule. But pop me an email, jpb@bic-immigration.com. And given that the extension is pretty much around the corner, I would suggest you get in touch sooner rather than later, because with self-employment, we also have to bear in mind your financial years. It's not the last 12 months, it's the last financial year, and it gets a little bit complicated from there on. Please just get in touch and we can see if we can't make a plan. So the next one, Shakir, if you or Dirk, either one of you guys, if you as a parent have a COS, so that's a certificate of sponsorship for those not in the know, so that's for a work permit. You have a job, you've got 2 children, one is in matric, so last year of school, one is 12. Which process will you follow to ensure that both children will be able to go with you? Right, which one of you want to grab this one?
Perhaps I'll take that one quickly, JP. Well, generally that's going to depend, on your home circumstances, if I may. One of the biggest things that we need to take account of is the other parent still in the picture? That is my main question that I would always ask in a situation like this. The applicable route you will take is what's known as a points-based system dependent for the children. They typically just go with you. It's a much easier route than something like the spousal visas. But once again, it boils down to, is the other parent still in the picture? If the other parent is not in the picture any longer, but still alive, it gets significantly more difficult, because then you need to either prove that you have the sole responsibility for that child's upbringing, that the other parent is a British citizen or has settled status, or in the very last requirement, something the like of exceptional circumstances, or that unjustifiably harsh circumstances, thing like that. But once again, we'll need to know your circumstances. But in short, PBS dependent is what's known as your child dependent application.
Yeah, thanks, Dirk. And also bear in mind, once the child turns 18, it's really preferable to apply before the child turns 18. Your matric child, because after that it gets not impossible, but it gets really complicated. And your timings there are important, and how you deal with your intended date of travel, what your start date or your certificate of sponsorship is, sponsor notes, all kinds of things like that. Ursula, please feel free to email any of us. We'll be happy to have a bit of a deeper look into that for you. Chris asks, Shakir, does the health levy apply to children with indefinite leave to enter?
No, it is one of the lucky categories, shall we say, that a child applying for indefinite leave to enter, it does not attract the immigration health surcharge. Again, not just that, but even when you're inside the United Kingdom, when you apply for indefinite leave to remain, there is no immigration health surcharge payable. It's only for initial applications and extension applications once you come inside the United Kingdom. But with indefinite leave to enter or indefinite leave to remain, there's no immigration health surcharge.
Thank you, Shakir. Yvonne asks, is there a way to enter the UK without my spouse, but take my children with me and they naturalize in the UK while he stays and continues to work and support us in our current country of Singapore? Well, that depends on who's the British citizen, and it'll depend on quite a number of other factors. Shakir, you deal with things like this all the time. Anything to add?
No, I mean, not much, but the problem you're going to have with this kind of application is if the parents are still together, unfortunately such an application would not work. If it's just for the children, then it goes back to what Dirk said a little while ago regarding proving sole responsibility. And again, unfortunately, right now is not the forum for us to go into great detail regarding sole responsibility, but it is quite complicated. And again, it's one of those things that really would need to be discussed at some length with the applicant.
Yeah, and just to add, thank you, Shakir, and just to add to that, Yvonne, it also depends on what you mean by continue to work and support us in our current country of Singapore. You know, would it be a commuting thing, 1 week there, 1 week back? You know, we'll need more details to see if a plan can't be made there. But all of you would have seen a trend here. The more planning we can do in advance, the better the likelihood of success of any application. So again, please reach out sooner rather than later. Then Anonymous asks, I think a question that's on everybody's minds. Could you possibly explain why a British citizen has to prove and work for 6 months, earning the minimum threshold, 29K going up, but ancestral visas can just bring their family all the time, or, you know. Shakir, Dirk, do you guys want to try and answer this one? I know I've got my views on it, but this is being recorded, so I better not say them. Maybe you guys can be more diplomatic. I think it's nonsense, but yeah, go on.
I'm happy to answer that, JP. Look, unfortunately, the short and sweet, the answer is, well, that's just the way that they decided to draft immigration rules. I mean, they don't, unfortunately, go give us the reasons behind why they decided to have one rule in one way and a different rule in another way. But I mean, I'll give you an even worse scenario whereby somebody can come on an ancestral visa and their spouse, for example, could join them after the main applicant has spent 4.5 years. When their spouse joins them after 4.5 years, when they apply for indefinite, when they do their 5 years are completed, when they apply for their indefinite, the spouse can also get indefinite. So it's a strange anomaly whereby you could have somebody who's only spent 6 months inside the United Kingdom and is eligible to apply for indefinite leave to remain, but somebody who's a British citizen, their family members have to spend the whole 5-year period in order to get indefinite leave to remain. One thing I always say to my clients is, unfortunately, what we perceive to be fair and just is not necessarily the law, and vice versa. So sometimes we do come across rules which are unfair, which are not just, but unfortunately that's just the nature of the beast that we have to deal with. So, you know, it is that with the ancestry visa, one does have to remember though that an applicant will still have to show that they will either have a job already lined up inside the United Kingdom, or if they don't, then how they will financially support themselves and any family members whilst they look for employment. So although it's not a strict requirement as it is for a spouse visa, there are still requirements attached to an ancestry visa. Again, I could sit here and go on about it for an hour at least, but again, unfortunately, time doesn't allow it. But it's a very good question, but it's unfortunate, it's just the way the rules have been drafted.
Yeah, and I think just to add to that, the House of Lords released a statement. How long ago was it, Chika? 2 weeks or so?
Yeah.
Yeah, 2 weeks ago, where they were very, very critical of the Home Office about these new minimum income requirement changes and the lack of transparency, the lack of impact studies, how it really disadvantages young people, people not living in big cities. If you take even the £29,000, which is the current lowest income requirement, if you live in certain parts of the UK, that's a lot of money to earn for anybody. If you're 22 years old and you live in the Outer Hebrides in Scotland, you're not going to earn that. So does that mean you can't take your family with you? I think there's going to be a lot of legal challenges. I know a lot of firms, us including really, I suppose, are lining things up to start with pre-action protocols and judicial reviews as we get to it further. I think watch this space. I attended an OASC, which is our regulatory body conference online, and the Home Office gentleman who's idea, or I suppose implementation is his responsibility, did say, even though they have announced this phasing in, they'll first see what happens and what the impact of this £29,000 minimum will be, whether or not they're going to continue with the increases thereafter. Now, whether they just said that because there was a whole bunch of angry immigration lawyers on the other side of his web camera, or whether they're really going to do that, remains to be seen. And just final thoughts on that, and I'll get off my little Sipkas here, is the fact that there's an election coming up in the UK, and immigration is always a massive thing. So if you want to reduce net migration, it is easier to target your own citizens because you know where they are and they're law-abiding generally. So it is a little bit easier if you want to bring net migration down to implement legislation like this. Whether or not they're going to keep doing it, I don't know. Of course, once we know, we'll let everybody else know. But to answer Anonymous directly, I think it's grossly unfair and frankly disgusting that they're doing that. Is there a way to bring parents to the UK once we are settled if they live in South Africa, though not really ill? Short answer, it depends. Maybe they've got ancestry rights or something along those lines. One would need to evaluate your circumstances. But the test is really quite high. You have to show that they can't look after themselves physically. They need care. Otherwise, any application really is, you're setting yourself up for failure, and they're really expensive applications. So just tread carefully there. But generally speaking, I would say no. Jody Lint asked, Dirk mentioned the certificate of sponsorship and skills visa as an easier route than the family visa. Please can you elaborate as to why that is? I think you were referring to the minimum income requirement, Dirk, which is different for the certificate of sponsorship than it is for family migration, generally speaking.
Yeah, look at, and this relates to something that I wanted to address earlier as well. The thing that a lot of people don't understand is that we have different categories of visa applications, of course. And if you look on these online platforms, such as a Facebook, such as this group and that group, they will normally refer to an overarching category of a spouse. Now it's important to note that this can either be under the family category that we discussed today, where the minimum income requirement would apply, but they also refer to spouse as being a dependent of someone else on, for instance, their skilled worker visa or their ancestry visa. In this case, the minimum income requirement does not apply. There is a very, very small maintenance requirement, they call it, that you need to meet there. So that is kind of the sole difference. Remember that if we talk about what we refer to as a spousal application, this refers to the partner of a British citizen rather than the partner of a visa holder. And that's actually the main difference there. One thing to just reiterate there, a British citizen obviously cannot receive an ancestral visa or a skilled worker visa or something like that. So you are kind of forced to bring your family over under the Appendix FM or family category, as we discussed.
Unless, of course, they are a British citizen and they renounce their British citizenship and then apply for an ancestry visa. A bit extreme, but I'm just saying. Right. I think two more questions. We're going to call it a day. Shakir, if you can attend to this one. After a spousal visa is granted, how long do you have until you have to act on it? And do you all have to go in one go, I suppose? Or can a family go at different times? So mom and kids go start school, husband comes later after wrapping up work.
Yeah, I mean, you normally, the vision that is valid for 90 days, and the applicant must enter within that 90 days. And at the moment, the Home Office is still giving biometric residence permits when the applicant arrives inside the United Kingdom. That is due to be phased out at the end of the year. From January next year, will there be electronic visas only? But yes, you have 90 days from the date of the grant of the visa to enter. When you make the application, you can, on the application form, set down your intended date of travel. Again, there's not necessarily the Home Office will always follow that. Sometimes, unfortunately, they just don't look at that and just give the date they start the date from the date that they make the decision. But normally it's 90 days in which to enter the United Kingdom.
Thank you, Shakir. So last question from David Boyer, and please, everybody else, if we didn't manage to get your questions, forgive us, but email us. Promise you will respond. Email me directly if you don't get a response. I respond pretty quickly. I couldn't do woodworking in school, you see, so I took typing. So I type like a demon. Final comment on this, noting the visa expires in December 2024. Just make sure, please, if you have a BRP or a visa that ends at the end of this year, the government is moving over to an e-visa program. So many people's BRPs, biometric residence permit cards, would expire at the end of this year. You have to get yourself an e-visa. So it's simply an administrative process. If you've got any questions, let us know. It's pretty simple to do. But just bear in mind, just because your biometric residence permit card ends at the end of this year, same for everybody, or before, if your leave runs out before, of course, it doesn't mean you can necessarily then apply for indefinite leave to remain. All the normal rules apply, but just make sure you attend to getting an e-visa. You'll receive an email from the Home Office reminding you to do that. If they've got your email address, we will remind everybody in plenty of time as well. Otherwise, you'll have a bit of a trouble traveling, or if you go home for Christmas, maybe getting back for the new year without a valid BRP. Right, I think that's it for today, folks. I hope we've managed to be helpful. If there's anything else, please let us know. And again, forgive us for not getting to everybody. We appreciate everybody's attendance. And Jacinda, our amazing admin / HR / marketing guru, thank you so much for everything and always being there for us. Even though people don't necessarily see you, they're missing out or not seeing you, but we really appreciate everything. Shakir, Dirk, thank you so much for joining. And I hope everybody has a good night. Stay safe. Speak again.